Hello and welcome to this presentation on the Aboriginal Affairs Planning Authority Amendment Bill 2026. My name is Chris James and I'm the Director of the Aboriginal Lands Trust Divestment Program at the Department of Planning, Lands and Heritage and responsible for the Amendment Bill. The purpose of today is to provide a briefing on the proposed amendments to the Aboriginal Affairs Planning Authority Act, on what's proposed to change in the amendment bill prior to a green draft being made available in the coming months for comment. And I'd firstly like to acknowledge that I'm providing this presentation on the lands of the Whadjuk people of the Noongar Nation and pay respects to their elders past and present. And I also want to acknowledge that Aboriginal people across Western Australia have a significant stake in this legislative amendment project, and that the divestment of the Aboriginal Lands Trust estate is a matter of significance to Aboriginal people. And we recognise their enduring connection to country as well. So just to outline the presentation today, as many of you would be familiar, the state government has committed to the divestment of the Aboriginal Lands Trust estate into the direct control of Aboriginal people. And changes are proposed to the Aboriginal Affairs Planning Authority Act, which governs the Aboriginal Lands Trust estate, to remove some of the legislative barriers to divestment and create more opportunities to increase Aboriginal land ownership and management and improve outcomes for Aboriginal communities. Early consultation is now underway on proposed changes to the Act, and the purpose of this presentation is to provide an update on the amendments since they were first proposed in 2022, to provide an overview of the current amendment bill, including those changes that have arisen through consultation since 2022, and also to provide an early opportunity for people to engage on the amendment bill and be as well positioned as possible to comment when the amendment bill becomes available later this year. So I really want to emphasise that this is not the last opportunity to provide input, and the bill will be made available with further opportunities for stakeholders to review and comment as the legislation progresses. And the intention is that the feedback we receive at both at this stage and on the draft bill will be used to inform a final draft before it is introduced to Parliament later this year. So before we get into what's proposed to change under the amendment bill, I want to provide an overview of the project and where we've come to since 2022, and also a bit of an overview of the Aboriginal Lands Trust Divestment Program run by the department, which really provides the context for where those challenges in divestment are and why the Act needs to change. In terms of where the proposal came from, in 2017, the state government made an election commitment to divest the entire Aboriginal Lands Trust estate. And then in 2019, our department first received funding to establish a program to work towards the divestment of land to Aboriginal corporations, and has divested 27 properties to Aboriginal corporations today. Aboriginal stakeholders, through that engagement, have told us and government that there are some significant challenges in the legislation that are prohibiting divestment from occurring and changes required to the Act. So really, this amendment proposal has arisen because of feedback from Aboriginal stakeholders about what's not working in the current divestment program. And then in 2022, Cabinet first approved targeted amendments to the Act to remove barriers to and maximise opportunities for divestment. And I think it's important to emphasise that point, in that the changes proposed to the Act under this amendment bill are really quite narrow in scope and just targeted at those things that are going to maximise divestment outcomes. However, it is acknowledged that a fulsome review of the Act, given it is quite outdated now, being a 1972 Act, is required and will be undertaken by government following these targeted amendments. So firstly, to look at what the Aboriginal Affairs Planning Authority Act is and how it relates to divestment. The Act was made in 1972, and the purpose of the Act at that time was to provide consultation and other services for the economic, social and cultural advancement of Aboriginal people in Western Australia. And the Act established 4 statutory bodies, being the Aboriginal Affairs Planning Authority, the Aboriginal Lands Trust, and the Aboriginal Advisory Council, and the Aboriginal Affairs Coordinating Committee. The Aboriginal Lands Trust was established to own and manage land on behalf of Aboriginal people. And the Aboriginal Affairs Planning Authority was once a government agency with its own staff, but it's now simply the Minister for Aboriginal Affairs in corporate form. And it too owns and manages land on behalf of Aboriginal people. And the Aboriginal Lands Trust estate that we refer to is simply land that's held either by the Aboriginal Lands Trust or the Aboriginal Affairs Planning Authority. And that currently comprises 285 properties. Our department, the Department of Planning, Lands and Heritage, looks after the land management functions of the Act, as well as providing support to the Aboriginal Lands Trust and the Aboriginal Affairs Planning Authority. And then it's the Department of the Premier and Cabinet that looks after the other functions of the Act, including the Advisory Council and the Coordinating Committee. So really, the focus of this amendment bill is on the Aboriginal Lands Trust and the Aboriginal Affairs Planning Authority being the land component of the Act. This next slide shows a snapshot of the Aboriginal Lands Trust estate, or the ALT estate, as it exists today. And as I said earlier, it refers simply to land that's either held or managed by the Aboriginal Lands Trust or the Aboriginal Affairs Planning Authority. Much of the land in the estate was formerly native welfare reserves, and they were subsequently transferred into the Aboriginal Lands Trust or the authority after the AAPA Act was made in 1972. There are currently 285 properties in ALT estate located all over Western Australia. And as you can kind of see on the map, those properties are shown in red. And there's a better copy of that map available on the department's website. The ALT and the authority own and manage land in various tenures, and that includes free leases and reserves under the Land Administration Act, under the AAPA Act. Really importantly for this amendment bill proposal, 81 of those 285 properties in the ALT estate are what we refer to as Part 3 reserves under this Act. But they make up 93% of the land mass of the ALT estate. And so if we want to find a way to divest that entire ALT estate, we really need to find a way to divest those Part 3 reserves. And the other thing this slide shows is just how many different interest holders there are in the ALT estate, with 400 leases, 67 native title determinations and claims, and 142 communities on the land. There are many, many Aboriginal stakeholders that need to be consulted with and have an input on any divestment proposal. This next slide provides an overview of the key considerations under the divestment program administered by the department. And I wanted to talk through briefly what those key considerations are, because they impact how we're looking to amend the Act. So firstly, when we say divestment, we're simply referring to returning land that's currently in that Aboriginal Lands Trust estate into the direct control of Aboriginal people or entities, so that the Aboriginal Lands Trust no longer has any control or say about how that land is managed. And really the goal of divestment is for Aboriginal people to be able to use land tenure rights under state law to support long-lasting Aboriginal social, cultural and economic outcomes. And the key points in this slide and in any divestment proposal are that any divestment has to balance the interests of traditional owners and native title holders, Aboriginal communities, leaseholders, and residents. And a large part of our job in the divestment program is to facilitate workshops and discussions between those parties to attempt to reach agreement on any divestment proposal. And land will only be divested after that there has been extensive consultation with all of those Aboriginal stakeholders and an understanding of each party's aspirations for the land. In terms of the options for divestment, the state doesn't have a preference on the preferred tenure outcome, and land can be divested in any tenure available in the Land Administration Act 1997. And that includes freehold, conditional freehold, leasehold, reserves, also the new diversification lease, pastoral leases. It's really about working with those Aboriginal corporations seeking divestment and trying to find a tenure that best matches their aspirations. Importantly, the state pays all costs relating to the divestment of a property, and it is transferred free of charge regardless of the tenure selected. And before land is divested, the state needs to make sure that it inspects the land and cleans up any rubbish, hazards, or contamination that is on the land, because we don't want to be handing back land that is a liability for that Aboriginal corporation taking it on. And land can usually be divested for a broad range of purposes, including social, cultural, and economic uses. Further, in most cases, where a divestment affects native title rights and interests, that will be a future act under the Native Title Act, and an Indigenous land use agreement is required. And again, our department has funding to support that process. On that funding piece, and it's really important in how we're considering and addressing divestment of that entire estate. The state wants to make sure that Aboriginal corporations are properly supported to make informed decisions about divestment and long-term management. And therefore, there needs to be funding, and Aboriginal stakeholders have consistently told government that there needs to be more funding through the divestment program to support both their engagement in their program and also building their capacity specifically to manage the land, noting also that we're talking about, in some cases, large millions of hectares of land. So this slide outlines the types of funding that the department can provide currently through the divestment program. It includes funding for corporations to attend meetings and workshops with the department to hear about the divestment program, and so the department can provide all of the relevant land information and process information that it has so that corporations have a full picture of what divestment means. It includes funding to enable Aboriginal corporations and native title bodies corporate to obtain independent legal advice, including advice on draft Indigenous land use agreements and any tenure documentation prepared by the state. Funding is also available to meet the costs of that ILUA authorisation process, so communities can properly consider proposals in accordance with the Native Title Act. Where appropriate and requested, and where we're working with Aboriginal corporations on divestment, we're also able to support early engagement and some capacity building support to help build things like governance reviews so a corporation can consider how it wants to hold the land, things like strategic planning or economic opportunity assessments to work out what their priorities for divestment might be. And lastly, again, as a result of feedback from Aboriginal stakeholders who've said to government that there needs to be some transitional support where land is divested, we've managed to secure some funding to provide to Aboriginal corporations that receive divestment over an initial period of 5 years to support any landholding costs or early costs that might come up in those initial years and provide that transitional support. So now that we've covered what divestment is and the process, we also want to move on to why the Act needs to change. So throughout our divestment engagements with Aboriginal communities, leaseholders, native title holders, a number of challenges for divestment have kept coming up. And some of those challenges were directly related about how the Act worked and what its limitations are. So through those consultations, we've identified 5 key reasons, 5 main things why the Act needs to change. The first is that the Act is 50 years old and uses outdated terminology and does not consider the Native Title Act. The second is that the Aboriginal Lands Trust's duty to consult with Aboriginal people before making a decision on the use and management and divestment of the land is not clear under the current Act. The third is that Part 3 reserves can only be managed by the Aboriginal Lands Trust or the Aboriginal Affairs Planning Authority and can't be managed by an Aboriginal corporation or entity. Fourth, there is a lot of red tape in the Act that makes divestment of those Part 3 reserves really difficult and time-consuming. And lastly, there's lots of Aboriginal people that have a really strong connection to the ALT estate with differing views on how it should be divested and managed. So in terms of the consultation we've done on the Act to date, as I mentioned at the start, the amendment proposal really was a ground-up approach and a result of feedback from Aboriginal stakeholders who we were working with on the divestment program. And that's really informed these proposed amendments. Then, following government's announcement of the amendment proposal in March 2022, the department undertook a first round of consultations at 13 regional locations across the state. And that was attended by 250 people in person. And there were a number of submissions and feedback received that have been used to inform where the amendment bill is now and the drafting of that bill. Since that time, the department has continued to hold consultations with and continue to work with different Aboriginal stakeholders on divestment proposals and continue to raise the amendment bill in that context. And as a result of that consultation, there are 3 key things that have changed since we first proposed the amendments in 2022, which we wanted to cover up front. The first is that when we proposed this in 2022, there was a proposal to remove the power to proclaim new Part 3 reserves. And that was on the basis that government hadn't created a new Part 3 reserve since 1986. And intention of divestment is to hand land back to Aboriginal people and not add more land into the ALT estate. However, there was some very strong feedback from Aboriginal stakeholders and corporations about the need to retain that power in the Act, because there might be areas where we're investigating divestment of land, of other land that adjoins those Part 3 reserves and are significant to Aboriginal people, where we might want to consider proclaiming new areas of Part 3. And so the current amendment bill, that proposal has been withdrawn, and it is now simply there is no change proposed to that power to create a new Part 3 reserve, which currently exists under the Act. Noting also that the ability to create a new Part 3 reserve requires the approval of both houses of Parliament. So that government oversight of the new Part 3 reserves is still retained. Secondly, we received very strong feedback about the need to update the enforcement provisions of the Act relating to trespass on Part 3 reserves, because currently under the Act, those penalties are not strong and they are not providing an effective deterrent. So the amendment bill now seeks to provide targeted updates to those enforcement provisions. And lastly, it was originally proposed that the amendment bill would provide for the dissolution of the Aboriginal Lands Trust. However, again, after feedback from stakeholders on the need to allow sufficient time for divestment and ensure divestment can only occur when Aboriginal stakeholders are ready, willing and able to progress, there's an acknowledgement in government that divestment will need to have a staged approach in line with Aboriginal stakeholder priorities. and that there may even be some portions of the ALT estate that should be retained by the ALT, at least for the time being, so it can continue to manage any hazards or liabilities on the land. And so that proposal to dissolve the ALT has now been withdrawn as well. So now we've looked at why the Act needs to change. We're going to cover next the 7 key areas of the Act that are proposed to change under the Amendment Bill. Starting with native title. Because the Act was created in 1972, it predates native title. And since then, native title has become a central part of how land is recognised and managed across Australia. In practice, all Aboriginal Lands Trust investment projects already proceed subject to the Native Title Act. And that means that native title rights and interests are always recognised and must be dealt with before land can be divested. Where land is divested, an Indigenous land use agreement is required with the native title body. And this allows native title rights and interests to be protected in any divestment outcome. And importantly, the department provides funding so RNTBCs can obtain their own independent legal advice and to support the costs of ILUA authorisation. And this is about ensuring informed decision-making and proper consent. However, through consultation with Aboriginal stakeholders, they've told us that the interaction between native title and divestment is not always clear under the current legislation because the legislation predates native title. And the proposed amendments respond directly to that feedback. They don't change how native title operates, but they clarify how the Act, the AAPA Act, aligns with the Native Title Act. And really, the intent is to improve clarity, certainty, and transparency about how native title will be addressed through any divestment proposal. The next change relates to the definition of Aboriginal person under the Act. Under the current Act, the definitions used are of persons of Aboriginal descent that don't reflect current understanding and laws. The proposed changes to the AAPA Act will bring that Act in line with other laws in how it defines Aboriginal people by including a new 3-part definition of Aboriginal person consistent with how other legislation defines the term. And that's that 3-part definition there. So a person who is wholly or partly descended from the original inhabitants of Australia and identifies as an Aboriginal person and is accepted as an Aboriginal person by an Aboriginal community in which they live. The next change relates to providing that clarity about who the ALT must consult with on divestment. So at present, under the Aboriginal Affairs Planning Authority Act, the ALT has a duty to use and manage the land, which includes divestment, in accordance with the wishes of the Aboriginal inhabitants of the area, as so far as that can be ascertained and is practicable. And that term is outdated, but it also is undefined in the Aboriginal Affairs Planning Authority Act, which means there can be a lot of uncertainty about who the ALT will actually consult with on any proposal. So in practice, the current practice of the ALT, because that term is undefined, is to take a really broad view of who those Aboriginal stakeholders are that must be consulted. And that includes registered native title claimants, registered native title body corporate, Aboriginal leaseholders, community governing bodies, and any Aboriginal residents not otherwise represented by those groups. And so what the proposal is for the amendment bill is to define who those Aboriginal stakeholders are that must be consulted consistent with the current practice of the ALT. And that would include all of those stakeholders I just referenced, as well as providing an additional ability for the ALT to determine by resolution that an additional stakeholder may need to be consulted. And this is particularly relevant and important for sites like former missions that might have significance to Aboriginal people across Australia who might not otherwise be represented by one of those groups. And so the bill proposes to define Aboriginal stakeholder to include all of those parties, but it does not change the requirement to consult. It strengthens it by providing clarity and consistency about the ALT's current practice. The next change we want to look at is the changes to Part 3 reserves. But before we do, I just want to give an overview of what a Part 3 reserve is. So a Part 3 reserve are Land Administration Act reserves that are proclaimed under Part 3 of the Aboriginal Affairs Planning Authority Act to be for the benefit of Aboriginal people, usually because they have particular significance to Aboriginal people. And special protections are given to Part 3 reserves when they're proclaimed under that section. The first is that it's held by the authority for the benefit of Aboriginal people with no end date. The next key protection is that all non-Aboriginal people, other than government officers and members of Parliament, must have a permit before they enter or remain on Part 3 reserves. And if they don't have a permit, they commit an offence and can be prosecuted. Secondly, parliamentary approval is required before government can cancel or change the boundaries of a Part 3 reserve, which creates a very strong form of land tenure. Part 3 reserves are also treated differently under the Mining Act, in that the Minister for Mines and Petroleum must consult with the Minister for Aboriginal Affairs before giving mining companies permission to explore or mine on a Part 3 reserve. And the Minister for Aboriginal Affairs must consult with the Aboriginal Lands Trust, who must in turn consult with all of those Aboriginal stakeholders. And that requirement is in addition to the requirement to obtain a permit before entering the land. And lastly, before any other government agency can grant an interest on the land, they have to seek the approval of the Aboriginal Affairs Planning Authority. So these protections are used by Aboriginal communities, and what stakeholders have told us, communities and native title holders have told us, is that they really rely on these protections to control who enters their communities and how they behave, to safeguard privacy. Many communities said they use them in their response to COVID-19, and they said they also provide a really strong position to negotiate with mining companies and other businesses that are looking to come onto the land. And these protections are also really useful in protecting any cultural heritage on that land and looking after the environment. And as I said earlier, these Part 3 reserves make up 93% of the Aboriginal Lands Trust estate. And under the current Act, they can only be held by the Aboriginal Lands Trust or the Aboriginal Affairs Planning Authority, which means if we want to divest that land and hand that land back to an Aboriginal corporation, we have to go through a parliamentary process to deproclaim that land as a Part 3 reserve and remove those special protections to allow the Minister for Lands to then grant another tenure like freehold or leasehold or reserve. And for those Aboriginal corporations and native title holders and communities who really rely on the benefit of those protections, they've told government that they would prefer to retain the status quo and not proceed with divestment if it meant giving up those protections. And there's currently no form of tenure under the Land Administration Act that provides those same protections to the same degree. So these Part 3 reserves are really important, and we currently have no way under the Act to divest them. So the proposed changes to the Aboriginal Affairs Planning Authority Act will give Aboriginal corporations the option to control and manage their own Part 3 reserves with all of those special protections in place. It's proposed that the land would remain vested in the authority which is essential to ensuring those Part 3 protections remain and the land continues to be set aside for the benefit of all Aboriginal people. It's proposed that the authority could make an order conferring management and control of a Part 3 reserve on an Aboriginal corporation, and that we would retain all of the special protections mentioned in that previous slide because of that underlying vesting remaining in the authority. The order could also be subject to conditions similar to a management order under the Land Administration Act, and it would have the power to lease, license and sublease over that land as well. The order would not create an interest in land, and where a Part 3 order to confer management is revoked, importantly, because there may be situations where an Aboriginal corporation no longer wants to manage that land, we need to provide a way that that land is not lost from the Part 3 estate. And that by retaining the underlying vesting in the authority, it would ensure that if anything happened to the management of the land or that Part 3 that corporation managing the land, then that land continues to be part of the Part 3 estate, and government can then work with those Aboriginal stakeholders again to try and hand back management. Related to the divestment of those Part 3 reserves and providing an ability to divest them, we also want to look at where an Aboriginal corporation now manages a Part 3 reserve, giving it the option to grant the permits itself rather than the Minister for Aboriginal Affairs, who currently has that power. And this would be an option that the corporation could look to pursue, not a requirement, because it may be that some corporations don't want the administrative burden of managing that permit system. And reforms recognise that administering permits is a practical and administrative responsibility. And so the approach of having that as a separate ability to give the power to grant permits allows time for the department and the Aboriginal corporation to work together to build capacity and whatever capacity they need to manage permits effectively in a way that suits their community and local circumstances. And so overall, the intent of the amendments is to increase the power of Aboriginal corporations and self-determination in managing the land, while ensuring those safeguards remain in place and decisions are made by those closest to country. This next change also relates to Part 3 reserves, but circumstances where an Aboriginal corporation decides they don't want to hold the land in Part 3, but they would prefer a different tenure option, like owning the land outright in freehold or another tenure option under the Land Administration Act. In those circumstances, there are a number of steps government has to go through in order to deproclaim the Part 3 status of the land, and that parliamentary process can take 12 to 24 months. And requires the Minister for Aboriginal Affairs to make a recommendation to the Governor, and the Aboriginal Affairs Planning Authority must be referred to and prepare a report that is then presented to both houses of Parliament for 14 days. And either house could pass a resolution rejecting it. This makes divestment of the whole or even a portion of those Part 3 reserves really difficult and lengthy and uncertain because we can't predict that final decision. The amendment bill proposes an exemption to those parliamentary steps for divestment. If we want to divest a Part 3 reserve to an Aboriginal corporation or entity in another tenure, or if we want to change the boundaries of a Part 3 reserve so we can divest a portion of it to an Aboriginal corporation in another tenure. But really importantly, there would be no change to the requirements for divestment, which would still require the Aboriginal Lands Trust to consult with all of those Aboriginal stakeholders, the Aboriginal stakeholders to make a recommendation to the Aboriginal Lands Trust, and the Minister to approve the deproclamation or the change of those boundaries. Similarly, Where these Part 3 reserves exist, there are currently a lot of telephone, power, water, gas, and other services, including main roads, that are located on these Part 3 reserves, and there can be uncertainty about who is responsible for looking after those services and roads. And again, if we want to change the boundary of a Part 3 reserve to excise land, excise those services or roads out of that reserve, we would need to go through the same parliamentary step for each change. And again, that doesn't allow a lot of flexibility to consider different portions of the reserve. And what the amendment bill proposes is that there would again be an exemption from those parliamentary steps if there is support from Aboriginal stakeholders to change the boundaries of those reserve lands so they don't overlap telephone, power, water, and gas service infrastructure or roads. And the infrastructure and roads could then be put on appropriate land tenure and placed under the management of the agency responsible for them. Again, it's important to note that there would be no change to the requirements for the Aboriginal Lands Trust to consult with all Aboriginal stakeholders and reach agreement before any land is excised from those Part 3 reserves. Importantly as well, all other cancelling a Part 3 reserve or changing the boundaries of a Part 3 reserve for any other reason would still require those parliamentary steps. There would only be an exemption where we're divesting that land to an Aboriginal corporation or for telephone, power, gas, water, and roads. And again, only where there's agreement of those Aboriginal stakeholders and the approval of the ALT. Lastly, and as I mentioned earlier, through consultation on the proposed changes, Aboriginal stakeholders advised that trespass on Aboriginal land is a long-standing issue. And even though the Part 3 requirement for a permit is really useful, there's an issue that people are accessing those reserves without obtaining that permit, and that can cause disruption and damage to significant heritage sites. Under the current Act, the ability to enforce trespass is limited because the fines available are really minimal and they don't provide a strong deterrent. And any prosecution has to occur within 1 year, which doesn't allow sufficient time to gather evidence, noting the remote nature of many of these reserves. The amendment bill will update the offence framework to strengthen enforcement of trespass on Part 3 reserves. And that includes extending the limitation period from 1 year up to 6 years, recognising that the current 12-month limit is impractical in remote areas, increasing the penalties so they reflect modern deterrence and also reflect the seriousness of unauthorised occupation and use of those Part 3 reserves. And they also look to introduce a continuing offence, allowing penalties to apply on a daily basis where unlawful trespass continues. The intent of these changes is really to reinforce the respect for Aboriginal land and support lawful land management by ensuring access occurs with proper permission. So that's it for the key changes to the Act. As I said, they are really quite targeted and narrow at removing some of those key barriers to divestment. And it is hoped that the proposed change to those Part 3 reserves to provide a vehicle to give control and management and decision-making authority to Aboriginal corporations will really unlock an ability to divest that 93% of the ALT estate that sits within those Part 3 reserves. In terms of the status of the project now, so as I mentioned, there was that first round of consultations in April to June 2022. And since that time, government has been considering that feedback and the legal issues for the drafting of the bill. Then in late 2024, the bill was deferred until after the March 2025 election because there was a full legislative agenda at the time. And then in December 2025, government reaffirmed its commitment to progressing the amendment bill and that it would be progressed into Parliament later this year. Drafting of the amendment bill commenced in December, and we've now commenced an early engagement and consultation with stakeholders. So all Aboriginal stakeholders on the ALT estate received a letter from the Minister inviting consultation and submissions on the amendment bill. And it is proposed the amendment bill will be made available for public consultation later this year, and any feedback received will be used to inform a final version before it is introduced to Parliament later this year. Thank you for your time listening to the presentation. If you'd like to stay up to date on all of the amendments proposed to the Act and to obtain further information, including fact sheets, please visit the department's website. We'll be continuing to provide information and answer any frequently asked questions online. This presentation will also be available in hard copy on the website, along with that further information to help explain the amendments. If you'd like to get in touch with the department or ask any questions, please contact us at the email address shown on the screen. Thank you very much for your time.